initiative at the Competition Innovation Lab at George Washington University. And today, I'm very glad to kick off the work of the European initiative of the Competition Innovation Lab with a great panel of members of the lab, of both advisors and senior fellows. And today we're here gathered to talk about the relationship between industrial policy in the European Union, of course, but also as a reaction to what is happening in the rest of the world, and competition policy. In particular, in the light of the Draghi Report and the suggestions provided by Mr. Draghi in his great and far-reaching report. And without further ado, I'm very glad to present and introduce the speakers of today's webinar. They are Jorge Padilla. He works at Complex Lexicon, and he's senior fellow at the Competition Innovation Lab. We have Yulia Lozanova. She works at the International Telecommunication Union in Geneva, and she's an advisor at the lab at the European Initiative. Then we have Professor Christian Bergquist. He works at the University of Copenhagen. He specializes in competition law, and he's a senior fellow at the lab. And finally, we have Christina Nordlander. She's an advisor at the European Initiative, and she's a senior lawyer and a very experienced lawyer in antitrust, both in London and in Brussels. So basically, a little bit of housekeeping rules. We will have 2 rounds of questions to our speakers. They will have 5 minutes each to answer. And in the last 10 minutes of today's webinar, we will have a general discussion between our speakers, and we will be glad to take any questions that you may have from anyone in the audience may have. And just feel free to write them down in the comment sections, and I will be happy to post them to our speakers today. So first question for our speakers really involves is really on the relationships between the rule of law in competition law and competition policy and the new wave of industrial policy that basically policymakers in European Union are preparing in order to stimulate growth in the European Union as suggested by the Draghi Report. What about legal predictability in enforcement of competition law? And what about the new tips provided by Mr. Draghi? For instance, the new competition tool that will be a new instrument for competition authorities in order to tackle some structural problem affecting the European markets. And what about all these suggestions may impact the legal predictability of competition law? So very broad question to kick off, and I'm really looking forward for the answers of our speakers. So we might start with Jorge Padilla, and Jorge, please, the floor is yours.
Thank you so much, Oscar. Real pleasure to be with all of you today. So the first thing I think that I would like to say is that why do we have a Draghi report? And the reason why we have a Draghi report is because the European economy is not performing well. It's not growing as it should. It has a productivity problem. And one of the reasons why it has a productivity problem, if not perhaps the most important one, is because our economy, our firms, our companies are unable to achieve scale. In this world, it is important, and in particular in the fundamental sectors, in the sectors that are driving growth in other regions of the world, high-tech sectors, it is crucial to have a scale. Now, you would say, well, but Europe has 450 million inhabitants, so it has a scale. But the reality is that that's not the case, because the single market is far from a reality. Spanish company, may have a scale above the 50 million in Spain, but it doesn't achieve the same scale that an American company would be able to achieve or is able to achieve in America, or that a Chinese company is able to achieve in China, or that an Indian company will be able to achieve in India. It's not just a question of population, what determines whether your companies achieve a scale or not. It's a question of whether you can reach out to those consumers, without barriers, without obstacles. And in Europe, there are still way too many obstacles, and Draghi has emphasized those. Now, you may say, well, but not everybody in India can afford the products and services that we're talking about. Yeah, but still, you have 400 million out of possibly 1.2 billion inhabitants that have the capacity to pay for the products that the companies develop. having a population that is larger than that of the United States, our companies are not able to achieve the same scale for all those reasons. We haven't achieved the single market. We need a scale. And that justifies many of the measures that are proposed in the Draghi Report. When we're talking about the state aid, when we're talking about changes in competition policy, in a sense, what Draghi is proposing is trying to allow our companies to achieve that scale and to be supported in a way that allows them to obtain a position of competitiveness that can compare with their rivals elsewhere. One of the reasons why Europe desperately looks for new markets, where we have now the Commission in India, where we have seen the agreement in Mercosur, is because sometimes our companies cannot achieve scale domestically and they have to go elsewhere to achieve that scale. And then it's fundamental that we have a position of competitiveness. The single market is a central objective. And one of the ideas that is half developed, in my opinion, I think it could have been developed further in the Draghi Report in order to consolidate and create this single market, is actually the market investigation tool that Oscar was referring to. We have in Europe a number of competition policy instruments. We have merger control. We will talk about that later on in this session. We have Article 101, Article 102. We have a state aid. We don't have a market investigation tool. One of the problems that we have with our competition law instruments is that to some extent they blur different types of objectives. On the one hand, consumer welfare. On the other hand, the single market. And yet there are also objectives related to helping our SMEs. My proposal here would be to take the Draghi Report and to advance forward. Preserve the consumer welfare standard in the application of Article 101 and Article 102. Preserve the principles that govern the way that we deal with the state aid and the way that we deal with mergers, with some caveats that I will refer to later. And adopt a market investigation tool, but with a separate objective. The market investigation tool, in my opinion, is not yet another competition law instrument aimed at achieving consumer welfare. It can do that if it helps us to fight tacit coordination, etc. But what I would do, and this would be unique to the European Union, is to use that market investigation tool in order to achieve the single market, to look at what are the obstacles to effective competition across borders within the Union. That would mean that we have a complementary instrument, one that doesn't interfere with the instruments that we know how to use well, that allows us finally to achieve what I think that we are not able to deliver at the moment, which is a single market for products, but very, very importantly, for services as well. I think that that would empower the European Commission to do what Draghi has in mind and would empower our companies to achieve the scale that is necessary to compete with their rivals in the US, with their rivals in China, with their future rivals in India and elsewhere, Brazil, etc., etc. All those places with large populations and single markets that will become our partners, but also our commercial rivals. Let me stop here. Thank you, Oscar.
Thank you, Jorge. That's a fascinating suggestions. The one of using the new competition tool, the market investigation remedy for achieving the internal market objective. I mean, that's fascinating and will deserve a whole webinar of that. Now, moving to Julia Lazanova, we'd like to hear your views, particularly in light of your experience and the International Communication Union and your year-long experience on digital regulation. The floor is yours, Julia.
Thank you very much, Oscar, and good afternoon to all colleagues who have connected to this really timely and certainly very insightful discussion. I would like to start with a very general observation. I think that the report that we have now as a subject of our discussion is a very timely one, if not an overdue. And I'm saying that from a position of someone who's been looking at international best practices in digital regulation. Well, it used to be ICT and telecom regulation, and now we're moving a lot more in the digital space. But the lighter regulatory approaches, the move towards exposed regulation as opposed to very heavy ex ante arrangements. All those are trends that we have been very actively advocating for at least 20 years everywhere in the world. Those are things that European countries have implemented for many of them at the national level as well in many of those areas. And it's interesting that the countries at the European Union level, which are the most advanced in that area, are actually those with the lighter regulatory regimes, and making use of additional tools, not only the traditional competition policy or industrial policies tools, but also the other tools that are a lot more adapted to regulating or facilitating the development of emerging technologies. So certainly that desire and that direction towards making the EU frameworks a lot more fit for the digital race is a natural one. It's an expected one, and certainly more than timely. I think looking back, it's also important to recognize that complexity of EU frameworks and the complexity of EU governance has been something that has not allowed the full potential of the digital players in the European Union to scale. It was interesting to listen to the World Economic Forum discussions last month. Of course, they were discussing the very same topic, emerging technologies and especially artificial intelligence. And it was interesting that the representative of NATO was talking about their capacity to adapt to the digital race. And he was sharing the realization that traditional structures and bureaucracies are holding us back. Now, he was obviously talking about NATO, not about EU, but there is certainly very interesting parallels that can be drawn there. And certainly the realization is something that might also be true for the European Union. So moving away from that very traditional structure, from the very traditional way of governance, is something that is not nice to have. It's actually required in digital. And this is what we've seen also happening in those places of the world where those technologies have been able to scale. And I found that the point that Jorge brought very interesting, the idea that a single market is something that would support the scaling up of European digital markets, and I'm sure this is true. However, I think it's important that we recognize that the biggest digital players that we have today, they didn't necessarily have access to a single market of many countries. They approached the whole development, scaling of technology from a different perspective, and they managed to scale globally. So there is also probably a learning there and an insight that there is probably more to it than having a single market or having a competition policy or having an industrial policy. And I guess one of the things that I was surprised not to see in the report is a little more emphasis on alternative or more agile ways of achieving those same objectives of the report or of EU policies in general. Those about competition more strictly speaking, but also about competitiveness more broadly. And in that sense, I'm thinking of the really big players we're really talking about in that discussion. So and I don't have all the stats in mind, but take the declining Facebook service of Meta. That's 3.3 billion monthly users. WhatsApp, I think we were at 3 billion monthly users last month. The smaller ones, Snapchat, that probably our children, all of us, use 800 million users a day. So for players of that scale, relying on policies for enforcing anything might be a little disproportionate. Those digital players, they're much bigger than countries. They're much bigger than the European Union or any other regional body, and they simply cannot be treated as just any player on which we can exercise jurisdiction, whether that's national or regional jurisdiction. And failing to recognize that they're too big to be treated as anyone else can actually lead to implementation problems. So it's not only a question about the frameworks that we want to put in place and the instruments that we want to tool ourselves with, but it's about to what extent we can realistically expect that those instruments will improve the status of our markets and would lead us to the achievement of those objectives. The bargaining power of those is just too considerable. Thank you. I'll stop here.
That's great. Thank you, Julia. A lot of food for thought for the moment. Could you please mute yourself? That's great. Okay, and now we will jump to our third speaker of today, Christian Berghurst. The floor is yours, and
thanks a lot.
Continue the conversation.
Thanks a lot. You know, reading the report is like eating a box of mixed chocolate. There's something you like and something you don't like, and there's something for everybody. You know, I kind of like the part where Draghi mentioned that there's probably too much regulation, and this regulation is holding back Europe. I think that the non-completion of the single market is highly problematic. And it is obvious that once we move to services, you know, there's actually a lot of restriction on your ability to take service across the border. And I think this is definitely something we need to work on. But I also feel that to some extent, there's actually two reports. There is part that looks into all the problems, and here I agree in most of the analysis. And then there's a second part where some solutions are sketched out. And here I actually see a conflict, because if we sort of agree to the idea that there's too much regulation, it is slightly strange to see Draghi actually recommending that we amend Regulation 1/2003 to allow for better ex post evaluation of mergers by essentially using more behavioral commitment that forces the party to provide a lot of data. I'm not entirely certain what Draghi is hoping to achieve by that, but it would inescapably translate DG.com into a regulator rather than forcer, and will also be somewhat burdensome on the parties. You know, is that what we want? You know, unlike Hawke, I'm not particularly, I don't really look that favorable about the idea of a new competition tool. I think that the main problem pertains to state aid, lack of fiscal responsibility, and national regulation, and I don't think the new competition tool would be tailored to address those. You know, we have other provisions, but the European community are reluctant to rely on these. The Draghi report says that we need the new competition tool to address tacit collusion. I disagree. I actually think the tacit collusion, to the extent there is really a problem, would be covered by Article 101 or 102, and that's also at least a position of the DG.com in the horizontal guidelines. Another issue that I'm sort of contemplating is that the report says that we need better guidelines or horizontal cooperation agreement. And, you know, I agree, but I don't think we actually need better guidelines. I actually think that the horizontal guidelines DG.com put out last year is actually good. The problem is that too many national competition authorities constantly try to push the notion of object restriction to make their life simpler. I would very much like to see that roll back. So my main initial take is that there's two reports actually. One that outlining all the problems, which I kind of like, and then there's a lot of solutions where I'm actually I'm skeptical about many of them, and that is my opening observation.
Thank you, Christian. You've been very short but very sharp, I would say. And as expected, we're not on the same page on the Draghi report and on suggestions proposed, which is good and great for discussion. Now let's move to our final speaker. Last but not least, we have Christina Nordlander with us. And Christina, the floor is yours.
Thank you so much. I will definitely try to be sharp. I might not be as short, but anyway, I'll start by saying thank you, Oscar and GW, for this really excellent panel and topic and initiative. I'm very proud to be a part of it. Can you hear me okay, Oscar? Am I coming through? Yeah, okay.
Yes,
good.
we do.
So I wanted to start these kind of opening comments by just two kind of big picture intro comments relating to our first topic. First of all, one thing that's very, very striking to me looking at kind of the background and introduction to the Draghi Report is that it seems to be almost all about tech, all about digital markets. I think the report says that looking at the kind of US versus EU innovation and growth gap, it's basically all about digital, because if we take away the tech sector, then the EU economy has basically grown on par with the US economy. So I think that's really interesting that a lot of the malaise that we're kind of talking about is in the tech space, and I'll come back to that. Secondly, and this is maybe a bit of a boring lawyerly comment, I'll take my role here on the panel as the lawyer. You mentioned, Oscar, in your introduction, legal predictability. And I think that's really, really important. So I want to pick that up, because I think what's missing sometimes in this debate, I mean, there's lots of debate about the crisis of competitiveness and what to do and Draghi. But I think it's very important when we think about competition rules and competition policy that we really need predictability and legal certainty. And very briefly, there are many reasons for that. I mean, one obvious reason when we look at competition rules, is that this is law enforcement. I mean, often with quasi-criminal sanctions. And so we really need clear and objective rules that are enforceable. And I'll come back to the courts as well. And, we need rules that the courts will accept and enforce. So I think that's important in discussing all these different policy ideas and initiatives. And secondly, I having advised a lot of big tech clients in the Brussels bubble for the past kind of 25 years or so, I'm sure I'm not the only one who constantly hears from my clients that it's not just about what the rules say about the substance, but it's also about having predictable and stable and clear rules in order to have a good investment and deal making climate and a good climate for innovation. So again, I think that's really important, because, and I'm sure we'll get back to that in the more detailed discussion, some of these proposals, it's going to be all about how are the rules framed, how are they implemented, how are they applied, to actually make a difference and make it work. So very, very briefly, given that this is all about tech and given those comments, I just wanted to briefly look a bit at what's happening in tech and how does that kind of relate to what Draghi is proposing. And just to make my comments a little bit controversial, maybe, I think a lot of what we see happening in tech is kind of slightly contradictory to what Draghi is proposing. I think what's happening is not necessarily in line where we want to go in a number of ways. I mean, obviously, one of the key themes of the report is kind of the issue of heavy regulation that's restricting, growth and innovation in Europe. I find it interesting that the report is very pro DMA, the Digital Markets Act. One of the chapters is about enforcing the DMA. I mean, what I see in my practice is and we've had endless discussions on this, is that obviously the DMA is a very heavy regulatory framework. It's very unclear. Lots of stuff will be stuck in the courts forever, and we have lots of enforcement actions now by DG Comp. So I think it's of course a regulation that applies to a limited set of companies, but it's clearly heavy regulation, which is not necessarily in line with what Draghi is proposing. It's also heavy regulation that tries to apply kind of a one-size-fits-all approach to very different innovative business models and companies. And I think also it's slightly again going in a different direction than what Draghi is proposing, in the sense that it's an ex-ante, it's a heavy ex-ante, one-size-fits-all, no assessment really of effects, as opposed to, I think, the kind of ex-post shift that Draghi is proposing. So can go into lots more discussion there, but question mark, is the DMA kind of going in the direction we need? And I think, Oscar, you had said, you had welcome ideas on future research. I mean, I'm sure, everyone is all over this, but I'd be curious to see research on what are we actually achieving with the digital regulations that we have. Are we fostering market entry? Are we fostering interoperability, which I think is one of the things Draghi is saying he wants to, us to achieve? And are we fostering innovation? And there's, again, to be a little bit controversial, one might say, the DMA restrains, big US companies in favor of European entry, to be a little bit, again, a bit controversial. But I mean, I don't really think that's what we're seeing. And again, I'd welcome some research. How is this actually playing out, and are we getting some entry and innovation as hoped under this framework? There are a couple of other points I wanted to make. I mean, we've also, part of what Draghi is saying is, this idea of kind of safe harbors. There's an idea of an AI sandbox, trying to allow more cooperation, collaboration, to foster innovation, to foster, vertical AI implementation, etc. And I think those are all very interesting ideas. Again, I think it's all going to be about how is it implemented? Is there going to be legal certainty? I mean, interestingly, the GDPR is identified as a big hurdle here, which is interesting because that's, of course, a big piece of, proud European regulation. And I mean, again, it'll be really important how this is all put to practice, because, I mean, we saw, I think Christian mentioned the horizontal guidelines. I mean, we've seen previous guidance on, sustainability collaboration, which I think was largely welcome, but which also led to issues because different authorities, national authorities, took different approaches versus the European Commission on, what kind of benefits could be weighed against the restrictions of competition, etc. So I mean, it's we need this to be done in a good way for it to work. And finally, maybe I also think, again, coming back to the courts here, if we're talking about competition rules and policies, I mean, I do think we're seeing also some developments in the courts and in the guidance being proposed that are, again, maybe not completely in harmony with some of the things Draghi is saying. I think Christian mentioned the kind of the object, the kind of move towards object restrictions, which is not necessarily the flexibility that we need in looking at collaborations. We have new guidance coming on abuse of dominance, Article 102, where we're going away from effects-based towards more of a presumption-based approach. And I am going to finish, Oscar, in 2 seconds. I'm out of time. I mean, also, I think we see a bit of a suspicion of ecosystems and vertical integration in the digital world. Self-preferencing theories. We also wanted to mention the very recent Court of Justice Grand Chamber Google outer judgment we had a few days ago, which is very interesting because it kind of seems to suggest that you have very far-reaching obligations if you have market power to if you have a digital platform or ecosystem to allow interoperability and access to potentially to competitors. And it seems to also potentially incentivize closed as opposed to open systems, which I think is, again, not necessarily where we might want to go in terms of innovation incentives. So I've got lots of points, but I'll stop there. I guess my, again, attempts to be slightly controversial is that I'm not sure things are going in the direction that Draghi might want in every way in what we're seeing in tech and competition policies. Thanks.
Thank you, Christina, and thank you all for this first round of answers. I think you all hit the nails straight in the heads, in the many heads of the Draghi Report. And moving now to the second round of questions, after this broad coverage of the many issues that the Draghi Report put forward, we'd like to focus on merger control and how merger control may play a part in stimulating growth in the European Union. And we all know that the Draghi Report takes issue in merger control and antitrust analysis in merger control in order to make it more straightforward, but also to facilitate, let's say, enterprise freedom and to push the supervisory check by antitrust authorities on an ex post stage, as Christian already mentioned before in his answers. this will be highly controversial, I think, from a legal perspective. But I like to hear for Jorge what he thinks about merger control in the Draghi report and how we can ameliorate it. Thank you. Thank you, Jorge.
Very good. Very good. Thank you so much. And I think that, again, the ideas about merger control in the report go in the direction of trying to make it, to fit better the overall aim and goal and strategy of growth, and helping our companies to achieve a scale, and also to ensure that our companies become more productive. Merger control serves many purposes, but as a matter of economics, it does two, or serves two main objectives. One, it allows firms to grow a scale. Secondly, is a mechanism to force the exit of some firms. We want firms that are not performing, firms that are not productive, firms that are not competitive to exit the markets. And mergers is a way of doing that. Of course, you have bankruptcy rules and bankruptcy mechanisms, etc. But we know that in competitive markets, there is insufficient exit. Europe is populated by lots of zombie firms that are not delivering, firms that have returns on capital employed that are way below the weighted average cost of capital, firms that are not investing, firms that are not increasing productivity, but they remain there, sometimes supported even by state aid. And having a merger control policy that is too strict means that the exit of those firms is much more complicated. What do we need to do? I think that Draghi emphasizes the innovation defense, the scale defense, the investment defense. I would say also that we need to reconsider our failing firm defense. I think that the failing firm defense is designed so that it cannot be applied, or it can be applied only in extreme circumstances. We need a failing firm defense in combination with an efficiency defense and an innovation defense that allows us to get rid of those zombie firms and reallocate resources that currently are frozen in unproductive activities to firms that can invest and can deliver, and can compete in foreign markets and can compete in our domestic markets. So it is important that we make merger control a better exit mechanism. This is not an overall criticism of merger control in Europe. I think that by and large, merger control in Europe and in the member states works incredibly well. There are only a few instances where it fails to deliver. I think that those relate particularly to situations in which the merger would allow the exit of zombie firms or inefficient firms, and also situations in which the merger or the merger in question is going to allow significant investment. Competition authorities are understandably skeptical of efficiency arguments or investment arguments, because they are used to see lots of people promising things that they don't deliver. But I think that it is incumbent on them to be creative and to force the parties and the lawyers to be creative, increasing the scope for investment remedies like the ones that we have observed in the UK in the context of the Vodafone 3, and imposing constraints that effectively compel the emerging parties, if they make those commitments, to undertake them. A good example there would be the monitoring activity performed by the Spanish Competition Authority with respect to mergers. If they can monitor behavioral commitments that involve, we are not going to do this, we are not going to do that, they should also be able to monitor and enforce commitments where there are promises to act, to become active, in particular in investment and innovation. We don't need a radical changes, but we need to have a proper innovation defense. We need to be creative in the way that we design and enforce this kind of investment remedies. And definitely, please, let's get rid of the third condition in the failing firm defense, which means, because that condition makes the failing firm defense a failing firm provision.
Thank you, Jorge. Very much clear, your message. And now I think we had a good start of the conversation on merger control. We will now move to Julia. Of course, your background is completely different from that of a law professor or from Jorge, who's an economist, of course. But we really like to hear your view about the potential of merger when it comes to growth, economic growth in tech industries and more sensitive industries, especially in light of your expertise that covers, of course, not just the European Union, the single market, but the global market overall. So what's your take on the role of mergers or on market concentration when it comes to stimulating growth? And what do you think that regulation might help in these, or less regulation as well?
Those are very many questions. I'll try to address some of them or all of them as much as I can, and I'm certainly not going to compete with Jorge on the competition law discussion. I'm going to give you a broader perspective and hopefully helpful to complement that specialized discussion on mergers, but also to maybe open a little bit to the more practical implementation aspects of what we're discussing, because it's obviously a very abstract discussion, but it has a very, very concrete dimensions in reality. So I wanted to pick up from something that Christian said minutes ago about that, about the two parts of the Draghi report, the problem part and the solution part, and the slight mismatch that might be perceived between the two parts. And I feel a little bit the same. So I would like to bring that discussion to a different question. So what is the problem that we're solving with those solutions that are brought in the report? So is that innovation? Is that competition? Is that many other things? And it really seems to be the case. One of the initial analysis pieces in the report is about the lack of focus of Europe with regards to emerging technologies, and that's probably true. I mean, he's well positioned to know that. However, reading the report, the number of policy objectives and imperatives in this report is overwhelming. We talk about green transition, we talk about digital transition, we talk about maintaining social protection, we talk about leadership on the global digital scale. So, and the thing with those objectives is that they're not only complex, but they're also very, and they're not only concurrent, but they're also competitive objectives. For developing a lot more digital, we would, of course, need a lot more energy now. So not in 5 or 10 years when we complete the green transition, but really now, because if we don't have that energy to power those machines that we want to power, I mean, it's just not going to happen. And then, of course, we talk about maintaining the very European and very established, very, very important social protection dimension of policies while developing digital. There is a slight contradiction there as well, knowing that digital is making economies lose many jobs before they start actually building different markets and different models on which we can start growing new jobs. I was reading this morning on GitHub what 10 developers were doing last year. Today, for the same amount of work this year, GitHub needs 4. So that's jobs lost in the tech sector itself on a very, very rapid scale, before even we have the opportunity to review our economic systems and really adjust all those different mechanisms. So coming back to those very complex, very ambitious, very competitive objectives of the policy, it is a little difficult to see how we're going to solve them all in the best possible way. And I guess one of the problems in that discussion also, and in that whole area of digital, is the speed at which everything is happening. And the fact that everything is really happening at the global scale. So the report is looking at the world from a very European perspective and looking to see how the EU can fit the China US rivalry and be a player in that space. However, we have new players emerging in that area every day. India just announced a new AI program. They want to have a new artificial intelligence model, an LLM, in 10 months. that's very, very aggressive. That's very, and they would probably have it. They have everything to get one. China just today, actually, Tencent released a new Turbo S fast thinking machine. So it's incredible just to see the speed at which everything is developing. So when I listen to the discussion about merger controls and going through a number of processes in a very administratively kind of defined and structured and time intense way, I'm just wondering, how is that coinciding, or how is that not colliding with the speed at which the industries are actually advancing? So I guess I'm not bringing many answers, but I'm certainly bringing a lot of questions that might need to be reflected upon and answered before we can get to a solution of what is that we want to prioritize in terms of solutions. Thank you.
Thank you. Thank you, Julia. And I'm actually surprised by your answer, because you started by saying that you're not a competition law expert, but you managed to touch the most sensitive issues in merger control nowadays. So I'm very glad about your contribution. And indeed, thank you so much for your answers. You managed to really touch upon the influence of geopolitical strategic dimension of merger control and how it's influencing and impacting the European strategy. But now let's move to Christian Bergquist, and we really want to hear his views on merger control.
I think there's two areas where we could do better. I very much agree with Hawk in that the system is actually solid. The problem is that it's so expensive. I have not seen any recent study, but there was a study back in 2003 suggesting that the average price of getting or securing merger clearance was some 3.2 million euros. A lot has happened since 2003, but lawyer fees has not come down. And the problem is that you often need to do filing in several countries, even within the European community. And as a Danish lawyer, I'm not allowed to do that in Sweden, even though the system is the same and I understand the language. So I need to reach out to local counsel to do that. That drives up cost. And the solution is actually very simple. That is just simply to lower the threshold, allowing more mergers going to Brussels. I know it's controversial having a Dane say that he wants more Europe, but here I actually think it makes a lot of sense. The second area where we could do better is the guidelines. The horizontal guidelines are, in my opinion, bias forward intervention. Unless the merger has a market share below 15%, there is a need to extra filing. I think we could increase that to 20 or 25% because there's no basis to seeing these mergers as problematic. They would allow more mergers to benefit from the simple notification system. The non-horizontal guidelines are also slightly biased because they don't really say anything about ecosystem leverage, and that has actually been a major concern in a couple of recent mergers. So I also think they should be amended to incorporate the latest thinking. So I think when it comes to horizontal and the vertical guidelines, we could actually get much better understanding of the European Union's concern if those guidelines for 2004-2007 was actually updated, the horizontal to allow more mergers to pass without any reservations, and the non-horizontal to better take account of what has actually been practiced. So that is my observation when it comes to mergers.
Thank you, Christian. Again, you've been very, very short, but again, you covered a lot of substance, from expenses, from how much is expensive the merger control systems for firms, and as well as the thresholds and whether to increase the powers of the European Commission. These are highly sensitive issues as well. And I believe that Christina is the most fitted speaker in her behalf as a lawyer, as a very experienced lawyer in antitrust law, to answer these points as well. So we really look forward to hearing your views, Christina, on these.
Thank you very much, Oscar. I'll be fairly brief. I agree with Christian about the costs of multi-jurisdictional filings and more Europe. I'm not sure I want less lawyers' fees, though, but yeah, it's a good point. maybe just two points, and then I'm sure we'll have some discussion. And Jorge might tell me I'm wrong here, but I was looking at the Draghi report again this morning on merger control, and I actually find it a bit unclear and inconsistent on the relationship between kind of concentration and innovation. And I, I'm sure there is a lot of economic research on kind of market structure versus innovation incentives, but I do find it a bit inconsistent, because on the one hand, clearly, it says that we, part of the main reform drive is to kind of allow more concentration in Europe to meet competition from the US and China, that we should, allow maybe national champions or even close to monopolists, as long as, the pan-European or global market share is not as high. But on the other hand, there's also, I think, a very clear acknowledgement, especially in the tech sector, that part of the problem is that very few big firms are kind of dominating the sector, and of course that's part of what the DMA is there to address. And I think I saw somewhere the suggestion, and again, this is a question for the economists, but of some sort of U curve, that there's less innovation if you have too many fragmented players in the market, but then there's more innovation with a few players, and then there's less innovation again with a monopoly. And I guess it depends on the markets, but I'm curious, because I do see those kind of slightly different views popping up in different parts of the report and the proposals. And sometimes, again, to be a bit controversial, sometimes I have a bit of a feeling that European concentration is good and US concentration is bad, but again, I'm sure it depends on markets. But very important in terms of merger control to kind of understand, how we should think about concentration and innovation incentives. And we mentioned that the merger guidelines, I mean, I guess we will see those being amended. I think that's part of the commissioners, the new commissioners letter from the president, and I'm curious to see what comes through that process. The second thing I just wanted to touch on is the innovation defense, and Jorge touched on this. I mean, again, I think that that's a good idea. But all of us lawyers in the bubble, have heard forever and ever about the efficiencies defense becoming the efficiencies offense, and I'm just afraid of a similar risk here. So again, proof is in the pudding. We really need to see how this can get implemented, and I think we need, maybe we need not just potentially a change of the guidelines, but we might also need a bit of a change of of attitudes. I mean, I think we have, I hold our regulators in very high regard, and they're very smart people trying to do the right thing. But I think there is a bit of an intervention bias, and I would hope to see maybe a bit of a more collaborative approach, and a real focus on evidence and data in terms of innovation arguments, and of course taking them, maybe not being suspicious, but taking arguments seriously and looking at the data seriously, and really trying to get this right. And of course, a lot of, again, a boring lawyerly comment, but a lot of merger control also, of course, is about market definitions. So I mean, that's an obvious point here in terms of innovation or global competition. How do we look at market definition? And maybe we've had a bit of a restrictive approach there in some cases, that if we want to incentivize European companies to go and compete in global markets, maybe we need to get that assessment right in terms of, if the markets are truly global, and how competition works. Yeah, I think I'll leave it there for now, but I'm looking forward to hopefully having some time for discussion. Thanks.
Thank you, Christina, for your points. I think we managed again to cover a lot of issues involving merger control, and as we have 10 more minutes for keeping our conversation alive, I'd like to give each of you a 2-minute round for following up on on your answers or on the answers of the other speakers, if you want to cover other issues that have come up and you would like to touch upon. And so we will start again with Jorge, which I'm really curious to know as well his views on the, let's say, the ex post behavioral check that competition authorities, the European Commission in particular, should carry forward under the Draghi Report in order to incentivize, merger, and let's see what happens afterwards. Provided the European Commission or whoever for that will keep an eye on market on the behavior of the undertaking. Do you believe this is feasible or not? And anyway, the floor is yours.
Thank you so much. So ex post evaluation is always complicated, but as somebody trained as a mathematical economist and almost, by heart more of a mathematician than an economist, I believe in the scientific method. And the scientific method means that we don't think that anything is true. We simply say that for the time being, we have not been able to reject it. And we are testing once and again those beliefs that we hold in order to see whether they are true or they need to be evolved, improved, or changed. So ex post evaluations are part of that scientific process that leads us to think, are we doing the right thing or we should do things differently? So I'm very, very much in favor. One more point, and with this I will conclude. I think that what we ultimately want is to have European markets populated by several European champions and foreign champions. It's not about concentration and fragmentation. What we want is to have several important innovators, some of which are grown here and employ people here and develop talent here. We don't want monopoly. We want powerful companies in Europe. We cannot do that if we continue with the policies that we have been using in the past. As Albert Einstein used to say, if you see that the outcome of your endeavors and initiatives do not deliver, change your policies. Don't repeat the same mistakes once and again. Something has to change if what we have is not what we want.
Thank you. This reminds me about the Draghi suggestion to the European Parliament, do something. But anyway, let's move now to Julia and let's hear your take on what we said today.
I love what Jorge said. I mean, change your policy, change your strategy, change the way that you're doing things. I think it's that agility. I mean, that mindset that we need to keep inventing things. I mean, what has got us here is not going to take us there. I mean, this is very clear in the digital space. So certainly this is. That mindset is very critical going forward. So Christina mentioned something about a suspicion of ecosystems. I feel very strongly about those ecosystem approaches, and I know that they start getting a little bit of bad press because they are sometimes presented in a way that is a bit too superficial, maybe to say. But the genuine ecosystem approach to policy is really working and looking at and working out the dependencies between the different players in the market, building the value chains, facilitating those through regulation and policies, and addressing those issues that arise at every level, not necessarily through regulation and not necessarily through the court system when things have already gone wrong, but as much as possible negotiating solutions as we go. I think this is essential. It's a very different way of doing policy. It's a very different way of implementing policies, but I see no other way going forward because we just cannot remain reliant on the systems the traditional systems we have. And I'm not saying those should go away. I mean, we still need them very much. I'm just saying that in addition to that, we need to develop those experimentation spaces. We need to have regulators become facilitators a lot more than the traditional role of regulators. That collaboration that I think all of you spoke about, I mean, it's something that we need to start doing at different levels, and we need to go beyond the intention to collaborate. It's really about working out how we can help each other at the national level, at the regional level, among institutions, and with the markets that we're responsible for. So certainly there is a lot of change happening in the tech sector, which calls for a lot more change in the public sector, and I would like to see that as an opportunity. Thank you.
Thank you, Julia. And indeed, regulatory cooperation, not just in competition policy, but in tech regulation will be key, and we might even cover it in one of the next webinars of the lab throughout 2025. But now let's move to Christian, and let's hear your views. And I'd like to ask you just a very brief question on whether you believe there might actually be a Brussels effect comparing to what we are doing in the European Union for other jurisdictions, or if this narrative is just losing weight and attention.
There is a Brussels effect, definitely, but I'm not always convinced that it's a good one. But I would like to go back to something you said, because I didn't know that Draghi had told the European Parliament to do something. But I think if that is correct, which obviously it is, but I think that was actually the wrong audience. I think that much more could be attained if the member states took notice of what other member states are doing. And what do I mean about that? Well, I kind of, during our presentation, I kind of took notes because, there's been a lot of discussion about tech companies. I could be wrong, please forgive me if I'm wrong, but I think Spotify is Swedish. I believe that Booking.com is Dutch. Just Eat was at least originally Danish, but now I think it's English, and I think Volt is Finnish. So my point is that we do actually have quite successful tech companies in Europe, but they are concentrated in countries that at least I perceive to be more business friendly. And that means that there's definitely something about overregulation also on a national level. And I think we could probably achieve much more if the Brussels effect was not so much that the Brussels told what other countries globally should do, but it could also be that we within the European community, we kind of took stock on what other countries are doing in order to make it much more attractive to open a business, including less punishment if you actually fail.
Thank you, Christian. And your point on overregulation in the European Union is an important one, and it deserves a lot of attention, both from scholars and from policymakers. But now let's move to our final speaker. And Christina, you're lucky enough to have a question from our audience. Larry Landman asks whether the innovation defense that got a lot of attention nowadays, and also Jorge mentioned it, can actually be turned into an operable instrument under antitrust law. And what do you think based on your expertise in these? And the floor is yours, of course.
Well, I think yes. I mean, I kind of like the idea generally, but and I think we should, but we need to really learn our lessons from having, had the experience we've had with the so-called efficiencies defense. I mean, going into the detail of how it need to work, I think is too much for now. But I mean, I think it's really important, looking at how evidence is adduced and assessed, and where the burden and standard of proof lies, because I think part of the problem in the past has been that the burden of proving efficiencies, they have to be merger specific, etc., is just has maybe been too difficult and too high, and has happened at a stage of the assessment where you've already kind of established an anti-competitive effects. I think it depends on at what stage of the analysis do we look at the innovation effects, and what is the time frame, how closely, etc., etc. So there are lots of factors that really we would need to get right for this to actually work in practice, for people like myself and my clients, for us to actually be able to succeed on these arguments. I mean, I'm not sure if there's any case where efficiency and efficiency defense has actually won the day. So again, I think yes, in theory it could work, and yes, I think it could be a good idea, but it would really need to be done in a workable way where there's a real opportunity, and obviously also where you don't shoot yourself in the foot by putting forward arguments that are then used against you in the merger assessment, because I can tell you from experience that clients will very quickly get the hang of that and not put those arguments forward. So I hope that's a decent answer to that question. I'll be very, very brief in terms of a couple of other comments. I mean, I think just going slightly off track in response to what Christian just said, I mean, obviously, where tech companies, startups, pop up and are successful depends on lots of things that are beyond our conversation today. Funding. I mean, I know a lot of European. I mean, I'm Swedish. There's a lot of very vibrant tech community, AI community in Sweden, but a lot of people then go to the US. I was at a dinner the other night in Stockholm with lots of young AI startup entrepreneurs, and they were all European, but they've all got their companies now in California. And I think you mentioned, fear of failure. I mean, I think there's lots of cultural and financial market related reasons why tech innovation and the really big players, might not always be in Europe. Sorry, I was going to say a couple of other things. I mean, there are lots of things I like from the discussion today. I think Jorge is right that a huge problem is, the fact that the internal market isn't really working. So any way we can come up with to actually, make the internal market function, including, financial and digital, I think is super important. I like the idea of ex post, how are things actually playing out? I mentioned the DMA, for example. What are we actually achieving with some of our regulations, and are they, are they doing the right thing? And I also like the idea of kind of collaboration spaces, but again, it's very important in how that's implemented so that companies and their advisors actually have comfort and clear rules and aren't afraid of coming and talking to the regulators. And to finish off, I love what Julia said about regulators as facilitators. There needs to be trust, there needs to be kind of interaction for many of these things to work. So I think that was a nice way of putting it. Thank you.
Thank you, Christina, and special thanks to all of you, to Christian, to Jorge, and to Julia for your contribution today. I think it has been extremely relevant, both from young scholars and for policymakers involved in the sphere, and for anyone interested in the matter. So the time for today is over. We're very glad that you have been with us. Please keep an eye on our social media of the Competition Innovation Lab. We will come back with many more webinars and initiatives over 2025. But for the time being, I really want to say thank you to all of our speakers, and really look forward to see you again in the next webinar. Thank you again, and bye.